Well, hello, everyone. Thanks for joining us today. I'm Doug Bennett, Director of the New York Tech Alliance. In a few minutes, Paul Ellis, Managing Partner at Paul Ellis Law Group, will begin today's event and introduce our esteemed panel. Before that, I'd like to share a few items. Please note that we record our events to share with anyone unable to attend. Recordings are posted on NYTA's YouTube channel. To view this and past recordings, you can visit youtube.com/New York Tech Alliance. For anyone joining us for the first time, the New York Tech Alliance is a nonprofit organization serving the New York Tech community. At the core of our mission, we drive access, equity, and inclusion to make the New York Tech ecosystem the most diverse and dynamic in the world. To learn more about us, please visit nitech.org. Thanks to our annual sponsors who help make events like this one possible. Each has a presence on our website. You can learn more about them and how they support our community by going to nitech.org/sponsors. And special thanks to GSD Solutions and team for providing the event platform, technical and production support. You can learn more about GSD and how they support our community by going to nitech.org/sponsors_GSD_solutions. And lastly, we love and welcome support to help us produce and deliver our programming. 3 ways you can help include add a donation when you RSVP to one of our events, become an individual or corporate member of the New York Tech Alliance, or simply make a small donation. You can do so by going to nitech.org/support_NYTA. And with that, I'd like to introduce Paul Ellis. Hey, Paul, thanks for being with us today and organizing a great discussion and panel. I'll hand it over to you.
All right, Doug, thank you very much. Welcome all. Again, my name is Paul Ellis. I am a board member here at Tech Alliance. I also run this series of events on legal issues for technology companies. Those of you who are regulars for this series know that we've done events on VC finance, on pitching to investors, on protecting your IP, and various other relevant topics. Today's event, we've got a great topic: buying and selling privately held companies, process and key deal terms. Definitely a timely topic at a point when, excuse me, a lot of companies are looking at the possibility of acquisition in terms of their exit planning. We have a really outstanding panel. We have Ben Boissevain, founder and managing partner of Ascento Capital. We have Jeff Palley, tax partner at Anchin, and we have Al Wasserberger, serial entrepreneur and currently with Stormboard. So we're really pleased to have them all with us. To start off, we're just going to go around the screen quickly with introductions about our organizations. Again, my name is Paul Ellis. When I'm not doing Tech Alliance events, I am the managing partner of Paul Ellis Law Group. We are a 12-lawyer firm, does a lot of work with startup companies, both technology and technology-enabled companies. Our clients are looking to us to help them with cost-effective solutions to their legal issues so they can focus on growing their companies and executing on their business plans. All of our attorneys come out of top schools and major law firms, allowing us to offer big firm capabilities with the personalized attention and cost structure of a boutique. We represent across a bunch of areas. Beyond M&A, we do the life cycle of issues facing startup companies, including formation, venture capital, IP protection, employment agreements, equity plans, general operations. Recently, we've been getting a lot of clients out of the big tech firms who have found that our combination of startup expertise and reasonable cost structure is a very compelling solution for their legal issues. If you'd like to speak with me further, feel free to reach out by email or set up an appointment at my Calendly link. And with that, I will turn it over to Ben.
Yeah, hi, Ben Boissevain. I'm the founder of Ascento Capital. We're an investment bank in New York, focused 100% on the tech sector, and a lot of different subsectors within that: enterprise, software, martech, fintech, that changes annually depending upon the flavor of the year, which is interesting. We do a lot of sell sides on M&A, as well as occasional buy side, occasional valuation work, and occasional capital raise as well. Do a lot of international work. We reach out internationally in all our deals. Just one quick note on a deal we did in Sweden. Had a client in Sweden in the IoT space. Reached out to the logical parties, potential buyers, and we received written offers from a company in Taiwan, in Germany, in Israel, and a couple of offers in the US. And we narrowed that down and selected the company in the US, which was backed by the Riverside Group. So it's good to have an international auction process just to maximize value. Turn it back to you, Paul.
Ben, thanks very much. Let's go with Jeff.
Hi, my name is Jeff Palley. I'm a certified public accountant with a master's degree in taxation. I'm a senior tax partner at Anchin, Block and Anchin. Anchin, Block and Anchin has been around for over 100 years, helping clients with all their accounting and tax needs. I have not been there for 100 years, but for the last 30 years, I specialize in tax planning and all compliance issues involving the formation and restructuring of businesses, mostly closely held corporations, partnerships, limited liability companies for my high net wealth clients, so all the buy, sell issues. I'm the go-to person to solve all tax issues related to my clients' issues, mostly in buy and sells, putting companies together, taking companies apart. There's always different type of restructurings to do, and that's what I've been involved in. I'm a member of the American Institute of Certified Public Accountants. I'm also a member of the New York State Society of CPAs, where I was the chairman of the taxation committee for limited liability companies and partnerships for many years. And I turn it back to Paul.
All right, Jeff, thanks very much. Glad to have you. Let's go with Al.
And the unmute button. Hi, everybody. My name is Al Wasserberger. Obviously, that picture is more than a couple of days old as I've changed my hair. I'm a serial entrepreneur. I've done, as the bio says, 38 buyer, sell side, or financing transactions, including, interestingly, the last one was Streamweaver that I sold to BMC, represented by the banker at Ascento Capital, and the accounting work and tax structuring was done by our friends at Anchin. So no stranger to this group. And hopefully I can add the perspective of an entrepreneur as we go through this process today.
Al, thank you very much. I should say with your 38 transactions, you give new meaning to the term serial entrepreneur. That's super impressive. But I should say, in all seriousness, we've got a great panel. Al has a particular role here. He's, in a sense, the guy who's going to keep the rest of us honest, the rest of us service providers, and give the perspective of an entrepreneur who has been through this process many times. So I think between Jeff, Ben, myself, and Al, we've got a great group. So let's go to the first slide. So we have a lot of material that we're going to cover today. I will be going, in some cases, others will be taking the lead. I will probably be taking the lead on a bunch of these slides, and then leave it to the others to add perspectives, contrary views, war stories, and what have you. But we're going to power through a lot of stuff. What are we covering? General considerations approaching an M&A transaction. It's a complicated sort of transaction, and there's a lot for you to know. We're going to go through the process. What are the different stages, discussions, LOI, diligence, documentation. We're going to talk about the LOI, particularly what are the considerations when you are negotiating an LOI. What are the interests on both sides of the bargaining table. And then finally, we'll go over key LOI terms and issues, especially distinguishing between those that are binding from those that are non-binding. What we are not going to cover today, given that we only have a little over an hour, we're not going to talk about the process in deciding to sell. important issue. When is the right time? But it goes beyond this event. We'll talk a little bit about identifying potential buyers, but we're not going to go too deeply into that. Wealth management considerations, we will not be going too deeply into that. It is something that is important to be aware of. When you're exiting your company, if all goes well, it's a significant financial event for you, and it is important to get the right planning, the right advice to make the most of the proceeds of the sale. We are also not going to go into the details of negotiating definitive documents. That's really, that's largely a process managed by the lawyers. There's certainly a role for the principals, but that's a little bit inside baseball, further than we are going to go at this point. One more thing I should mention that we're not really going to touch on is the long-term preparation for the sale. The things, if you know that you're going to sell your company 12, 18, 24 months out, there are a number of things that you want to be thinking about well down the path so that you're ready, getting your documents in order, financials, whatever. That actually is the subject of an entirely different event that we've done in the past here at Tech Alliance. So if you go to the Tech Alliance YouTube channel or to my firm's website, the resources page, you'll see videos on long-term planning for an acquisition. Next slide, please. Okay, our goals today. This is a complex process, and as Al will probably tell you better than anyone, until you've been through it a few times, it is super complicated, very arcane, and the difficulty that you face selling your company especially is you're doing it for the first time against people who do this for a living and have gone through deal after deal after deal. So partly what we're trying to do is just sensitize you to the issues so that you have a little bit of a leg up and you're not doing it for the first time. Can't give you all the answers, but we want to identify the issues, identify the questions, get you thinking about the important points so you're a little bit aware of them. We are going to be focusing a little bit more on sell side than buy side, although many of the issues cut both ways. Next slide, please. Okay, general considerations, and then I'm going to turn it over to the rest of the panel. As I am fond of saying to my clients, time is not your friend. In most transactional matters, particularly M&A, time, as a seller especially, time has a way of cutting against you. So generally speaking, when you're in a process, moving it fast is important, especially as the seller, and we'll talk more about that later. You need to own the process in the deal. This is a really important point. You have advisors that are going to help you in different aspects of this that are experts in their sphere of expertise, but only you, as the principal, knows what's most important to you in the deal. And you have to, throughout the process, you need to know what's going on, what your advisors are negotiating. If people are getting stuck on points, you need to know what those points are, because sometimes you'll find that your lawyer is working on an issue or really digging in on an issue that it turns out may not be the most important issue to you. So you have limited bargaining power in a deal like this. Make sure you're using it wisely. Do not underestimate the time, amount of work to get a deal closed. It can take a long time, both hours in the week and months of your life to get a deal closed. Be aware of that. So next bullet, you devote sufficient resources to the process. You need to know that it is going to take a lot of time of whoever in the company is responsible for doing the deal. So make sure you've allocated responsibilities. Who is responsible for getting the deal done? Who's responsible for keeping the company running? Because whatever you do, you don't want to take your eyes off the ball and let your numbers, your financials start to slip while you're busy negotiating a deal. distinguish between motives of strategic and financial buyers. We may talk about this a little bit more later, but financial buyers are buying your company largely for the revenue stream. Strategic buyers, while they are interested in the revenue stream, are especially interested in how your solution may fit into what they're doing. It may be your IP, it may be your customers, it may be your team, whatever it is, there is something that makes your company a good strategic fit. And often strategic buyers can be a good solution because they will be willing to look at you not just as a revenue stream, but other aspects as well. Maintain confidentiality throughout the process. It's really, your company can be damaged if you don't maintain good confidentiality and the deal goes south. Be realistic in negotiations, but you have to be prepared to walk. Don't get so enamored of a deal that you're not prepared to walk away from it. I've seen this happen with my clients, that they really get smitten with a deal and they want to get it closed at all costs. And they start to make cuts, especially in the end of the process, that they might not have made in the beginning of the process, just because they're so focused on getting a deal done. And ultimately, that's really important in your negotiations. If you're the seller, the buyer has to feel that you are prepared to walk away, because if they don't recognize that, that weakens your bargaining power. Many deals fall through. Don't let your company get damaged in the process. I'd love to tell you that every deal that we start as M&A lawyers gets closed, but it just is not that way. Some of them don't close for various reasons, and you want to make sure that you don't get damaged along the way. Finally, work toward the best, but prepare for the worst. I mean, negotiate towards a good conclusion, but protect yourself against things that may go wrong along the way. With that, I will turn it over to the panel for thoughts, additional comments. Anybody?
Sure, I'll jump in. Still on I think you've advanced to the next slide, but
Can we go back a slide, please?
So like all of these bullet points are spot on. This is a new process for almost everybody that goes through it on the sell side, right? And I think I can safely say that buyers can be, and usually it's their job to be predatory. Like the difference in experience that Paul was just talking about is something that's part of the way that they go to market, right? And so the person who is running an M&A process at a strategic buyer, or the person that's running acquisition processes at private equity firms, their job is to get the best deal, and they've been through it enough times to be able to know all the different places to get turned. And even after 38 deals, I still learn something on every deal. Like I'll give you an example that Ben and I dealt with on the last deal. The buyer had a strategy that they waited until very, very late in the process, weeks before closing, until final documents were basically complete, before putting employment offers on the table to anybody in the company that was being acquired, including the founder of the business, not me, I was the chairman of the board of the company, but including the founder and key employees. Now, the reason that they did that was that they knew that the longer time that went through, the more the sellers are going to be committed to getting the deal done, and less likely they are going to be to walk away from the deal. And therefore, they felt like they were not going to have to do a huge amount of negotiating on those comp packages. Right now, Ben and I have been through this enough that we knew as we did the timeline early, this was going to be a risk area. And so we were able to coach all the folks that were getting their offers later. This is how you respond to them. This is how we deal with it, and allow Ben and I to negotiate those on your behalf, right? But somebody going through this without a banker, without an executive who saw this and understood that this was a tactic based on the idea that you're not going to want to walk away at the late stage of the deal, would have got trapped and probably would have ended up having to take bad packages and have key employees that weren't happy to sign, or even might hold up a deal, right? Because not everybody gets a vote in the boardroom, but a key employee who is somebody, key developer, key business development person, marketing person that says, hey, I'm not going to sign, can kill a whole deal. And the buyer knows that, right? So use your advisors, but remember it's a chess match, right? There is a winner and a loser. The kumbaya of everybody's always a win-win and wins and loses equally, that's a fairy tale. That's not what happens in these processes, right? Our job is to get the best deal for our companies, and their job is to get the best deal for theirs.
That's a great point, Al. Yeah, it's basically a war, right? So, buyer versus seller. And one of the more interesting things in M&A is that, you're trying to sell your company to I'm going through this right now at a very large tech company, right? On the other side of the table. And we've got the corporate champion involved, right? The guy at the company X, let's call it. It's not Twitter, company X. And company X, they're really interested and got a corporate champion, but he's got to get, his people together from all these different areas in the company, senior managers, VPs, operation guys. He's got to get their consensus, and that takes a long time. And that's why M&A takes so long, is to get that consensus. And, you need to feed that corporate champion material to help him, right, get the deal through. I think that's the key. It kind of flips after a while from, contentious with the corporate champion to trying to help the corporate champion. The other aspect of that is that every department has their own budget, right? So it's not going to go to Microsoft and, suggest 25 times revenue, and they have to take the deal, and it's nothing to them. It's only a couple $100 million. It's a rounding error. That's not the way to look at it. Every divisional manager is responsible for their own deals. And if they buy a company at a grossly overvalued price, they get fired, right? That's as simple as that. So you're dealing with a lot of different layers of a corporation. It's really important to understand that going into the M&A process.
Ben, thanks for that. Jeff, any thoughts on your side?
I think you really have to understand at the end of the day, and I'll go through it later when I talk about taxes, what you're going to have in your pocket at the end of the day. You want to get the deal through, and assuming there's both sides want to get the deal through, but then a lot of times there's a lot of things in the agreement that could really affect what you're going to have at the end of the day. You could read something, it could be a working capital adjustment specifically, and somebody might not focus on that, but it could change what you're getting substantially. So you have to understand the numbers, because at the end of the day, if you're going to sell, all you care about at the end of the day, if you're not going to be working for the new company, or you're not going to have equity in a new company, how much net cash you're going to have in your pocket. And that's what I do as an accountant. I want to make sure you maximize the cash at the end of the day. And that's the biggest thing.
Jeff, thanks for that. All right, let's go on to the next slide. By the way, we can hopefully take some Q&A as we go. So feel free to put any questions in the chat. We'll get to what we can. Okay, the team. As you get started down this process, get your team together. Your legal team, usually headed by an M&A lawyer. That should be someone who does M&A deals. It's not necessarily the principal lawyer for your company, but it could be. But sometimes, for example, if your company is in the real estate technology space, you may have a real estate lawyer as your principal lawyer. That's not necessarily someone who knows about buying and selling companies. I often find myself, I'll be working with in-house counsel or the outside specialist counsel. I'll be the M&A lawyer, and then their regular lawyer who understands the ins and outs of their business, and we'd be working side by side. There will also be specialized counsel, tax, IP, employment. That team is generally quarterbacked by your M&A lawyer, but that person should be someone who specializes. Accountant should be experienced in structuring deals and an expert in tax issues relating to M&A deals. Same thing. This should be a meaningful part of what they do, structuring M&A deals. As Jeff said, what's important at the end of the day is how much of the cash proceeds end up in your pocket. And if the tax aspects of the deal are not properly put together, that can have a meaningful swing on the purchase on your proceeds. Investment banker has a number of roles: identifying buyers, structuring the process, negotiating the deal, keeping the deal moving. There are a lot of roles that the investment banker plays that's really important. It is useful to have someone, if possible, who really specializes, like Ben is a tech, he works in the tech space. Someone like Ben who really knows tech is useful, rather than a generalist. Your lawyer should review the engagement letter between you and your investment banker. And lastly, your internal team, which goes to something I said before. It takes a lot of time to get a deal like this done. It's a big demand on your resources. I tell my clients it's useful to think about what the roles are of people in your company, and it may be worth figuring out who's going to focus on running the company and who's going to focus on getting the deal done. It doesn't mean there won't be some crossover, but allocating some responsibility can be useful. Guys, any comments on this?
Sure, I'm going to jump in. I'll jump in first this time, and then I promise I won't be first on the next slide, guys. So I have a couple of comments. The first thing is the team. Fielding a team is fielding a team, whether it's an M&A process or a customer sales process, or you're building a partnership, or you're putting a sporting event together, right? Everybody's got to have a position. Everybody's got to know their position. They've got to be able to work together and play off of each other, right? Your legal team is crucial for the success of a transaction, both in terms of technical knowledge. Here's the pitfalls. Here's what's normal. Here's what's market. Here's the risk. If you don't agree to this, the risk if you do agree to this, but also typically the lawyers are lead negotiators on legal terms. And so somebody that you want to go into battle with matters, right? I think from an accounting perspective, that last, I'll call it tough player thing doesn't matter as much as the technical stuff, but I have seen accountants on more than one occasion bring deal structure ideas to the table that say, hey, if you can structure it this way, you'll get more cash in your pocket and the buyer will have to lay out less cash out of their pocket. And that actually adds to the likelihood of a close on a deal. So this isn't just, hey, I'm going to get this much money, how do I not pay taxes on it? Deal structures really matter individually and from a corporate standpoint, right? And Ben and I have become friends after doing a deal together, and someday hopefully we'll do more deals together. But having your investment banker is your partner in this, right? Like this has been what, 2 or 3 times a day you and I talked through processes and strategy.
Easily, yeah.
Right. I don't even want to know how many text messages back and forth between you and I during the process of getting that last one done, right? So like you have to, again, have somebody who's going to represent you, but also somebody who will tell you the truth, who will tell you when you're wrong. Not that I was ever wrong, but other entrepreneurs, like Ben had to tell me a couple of times that I was wrong, and to drive through. There's one group that's missing here though, and that is your board and investors. So if you are a venture-backed company or you've got angel investors, there's a pretty good chance that I'll say something controversial, but as an entrepreneur, the other entrepreneurs will understand. Sometimes we have a hard time taking a venture partner's advice on operating our business. Their idea of what a product should be named or what a go-to-market strategy should be may or may not have the same credibility as others because we're in the fight and they're professional investors. The one thing they have done more often than you, guaranteed, is exit their investments. And so at this point, taking an investor or a board member and putting them on your operating team, you don't have to pay them, right? There's no payroll cost to that, but saying, okay, part of this exit committee is going to be you, and I'm going to need you to be by my side, guiding me as an insider and watching out for me and the other investors. Those are resources that you should tap. And if you're not venture backed, find friends, get advisors that are entrepreneurs who've been through it before that can help you to make sure that you're not stepping in something you're not supposed to step in, because lawyers come from a legal aspect, accountants come from an accountant aspect. The investment banker's job is to get the deal done at any cost. They get paid when the deal closes. having an entrepreneur who can look at your perspective is really important as part of the team.
I think it was
Ben,
important.
Or
Yeah,
Jeff? Go ahead.
Yeah, just one of the things that Al said, I think was, really important. And, when you talk about a team and all the teams have to work together, and, that's the most important thing, that everybody works together. I can't tell you how many times the other side of the deal had a tax issue, specifically with the deal. And their people couldn't figure out the answer to the tax issue, and that could have held up the deal. So helping out the other side could move the deal along, and it has, in numerous times. Then the other thing is sometimes you end up getting advice from the other side, okay? And sometimes the other side is not as good as your side. So do not rely on the other side, because maybe they don't have all your best interests in mind. So, just be aware of who your advisors are and who you're listening to, because you could have very big problems, that way. And I can go through a whole bunch of war stories, even, within the last 2 days, with different things that happen. But just be aware of your advisors. You have the best advisors, and watch who you're listening to.
Yeah, just one other point, Paul. I think the key is not to get completely sucked into the M&A process so that your business suffers, right? And I've seen it happen. It's that they get so enamored with the process, or first time, second time, third time, they're fascinated by it. They want to negotiate every point. I mean, you have to really trust your lawyer, your accountant, your banker, your board member, and to some extent, you definitely want to be involved, but you really want to focus on your operating business, because reality is, on the buy side of a deal, I had to cut the price in a deal because they were down 10% on their forecast, and they're down 10%. I cut the price 10%. So just focus in on, making sure you hit your numbers during the process as well.
All right, moving on. Next, there will be an NDA, your confidentiality agreement. Make sure you get it in place. Make sure it's reviewed by your lawyer. Many entrepreneurs, they will just, they sign NDAs all the time. They'll review them, they'll sign them, they'll move on. This is one that should be reviewed by your lawyer, because it matters. There's a lot at stake. Then we go on to next slide, which I will turn over to Ben. Guys, we're gonna have to move a little faster, so let's Ben, you go at it.
Sure. Yeah. So the key to the M&A process for buyers to get a pretty robust, large list together of potential buyers, and you want to be creative on the list. I mean, a lot of your logical buyers are not buying right now, particularly. They're not as active as they were 2 years ago. So try to be creative. Go after the core sector, obviously, but adjacent sectors as well. I sold a company in Switzerland that was doing mobile analytics, sold it to a mobile security company, Gemalto, which was then bought by Thales. But, so mobile analytics, mobile security, they were highly interested, and they paid top dollar for a mobile analytics company because it's exactly what they wanted. Go after international targets. Private equity is really very active on the portfolio basis. So they've got portfolio companies. They're trying to expand them through acquisition. So definitely approach private equity firms themselves as well as their add-ons. Huge pocket of very active M&A right now. Do a lot of research on buyers. Strategic fit is key. And then, as I said before, sell the deal internally. Connect with corporate development, connect with operations, right? With a specific division that is interested. We did that when we did that deal with the operations, were highly interested. It was hard to get corp dev interested, right? So you got to get both playing along, and eventually we closed that deal because both were highly interested. So that's the case.
Absolutely. And I'll reiterate what you just said about the size of the list. By admitting, I don't know that I've ever admitted this publicly, Ben, but you know it, the BMC who bought Streamweaver was not on my target list. The list that I gave to Ben, and I said, one of the buyers is going to come off of this list. Ben said, that's nice, but there's others we're going to look at. And he brought BMC as part of a package. And I said, boy, Ben, I just don't see it. They're backed by private equity. They're focused on different things. They're not a market leader in this space. And Ben said, I think they need to be a market leader and you could get them there. Let me pitch it. So we said, okay. And that ended up being the buyer that won the process, right? Because the business wanted it badly. So listen to Ben.
Vision of AI ops around it too. It's fascinating.
Yeah. Yeah.
All right, Ben, are you?
Yeah, we're done here. Yeah, absolutely.
All right. Okay, next slide, please. All right, so we'll talk about the LOI, or sometimes it'll just be a term sheet, but most typically it's LOI. Generally, this is offered up by the buyer. Why do we want an LOI? What purposes does it serve? LOI, letter of intent. I'll try to at least explain the jargon. An LOI, it is essentially, it's a summary of the deal terms. It's not essential, but it's important. As a lawyer, I always encourage my clients. Sometimes I'll have a client that will say, maybe on a smaller deal, oh, let's go right to documents. Don't do it. It's a bad plan. Even like I'll say, I don't care. It doesn't have to be signed. It doesn't have to be pretty. If it's just an email with the bullet points, even that is better than nothing, because it ensures if you've got the points on paper, you know that at some level there's fundamental agreement on principal deal terms, and you want to sort out the disagreement at the beginning before your lawyers start drafting documents. The last thing you want is to get the documents drafted and find out there's some fundamental disconnect in terms of what the deal terms are. So you always want something to summarize the deal. It's also the LOI provides a template to the lawyers when they're drafting. It just, in all respects, it simplifies the process, it streamlines, it provides a framework and makes it more likely that you get to your conclusion cost effectively and that you get there at all. It can be binding or non-binding, but even a non-binding LOI is going to have binding elements. So that's to say, often the principal terms in an LOI, the price, the deal structure, whatever it is, are technically non-binding terms. That is to say, if in the definitive documents, you cannot reach agreement on some of the details of the terms and the deal tanks, the non-binding terms will not be enforceable. But there are binding terms. We'll talk about that later. And so even in a non-binding term sheet, you need to take it seriously. I will have clients that will say, well, sometimes I'll have a client that will present an LOI to me. They'll say, okay, here, I already signed it. You didn't have a chance to look at it, but it's non-binding. We can always negotiate the points you don't like later. That's a really bad plan, because once you've got it on paper and once you've signed it, I can guarantee first meeting where you try to, I as your lawyer try to, work around the terms a little bit. They'll say, counselor, I have an LOI here signed by your client that says this is the term, and it'll be the whole way like that. So do not sign a LOI binding or non-binding without your lawyer having a look at it, or your accountant for that matter. And Jeff, maybe you want to go into those points quickly.
Yeah, I just want to go in, to some of the issues, and I really want to reiterate: do not sign an LOI without getting advice, from your side, because I've seen clients sign things, and it ended up that it was much better for them to sell the entity than to sell the assets. And it was a tremendous difference from a tax standpoint. And again, we'll go over all this after. And it ended up there was substantially less money in their pocket if they would have continued that way. It's a real uphill battle to change if they put down an entity sale or an asset sale, and then you want to change the thing. It's going to be a real uphill battle. Know what you're getting up front, because you assume you're getting cash. You might be getting stock. You might be getting a combination of cash and stock. Those could be tremendously different. What you're going to put in your pocket, how much taxes you're going to pay, even when you're going to, pay the taxes, specifically, because you could get all stock up front and somebody's going to tell you you owe all taxes today. So know what you're getting, understand the timing issues. If you're going to get cash and you're going to get paid out over time, understand if you're going to get paid out over time, when you're going to pay the taxes on this, because you have to make sure you qualify for something. Again, we'll go through it after, something, an installment sale. You don't want to pay taxes before you get the money. So some of these things could turn into a disaster. And if it's in the LOI and you signed it, again, uphill battle. So that's what I have to say just about the LOI.
Yeah.
Let me add to that.
Go ahead, Al,
that-
sorry.
Sorry, Ben. So first of all, I do not do deals without an LOI. You don't need an LOI to do a deal, but the risk is all on you as the seller if you don't have an LOI, right? So that's the first thing. The second thing is, if you think about how hard or easy it is to negotiate a term and how expensive it is to negotiate a term at the beginning of a process versus at the end of the process, there's a reason why we do most of the work in the LOI and why buyers want not to do most of the work in the LOI. So the buyers want you to be committed to the sale. They're going to get you on an exclusivity clause in the LOI, so you're not going to be able to shop to other people. Makes it more difficult for you to walk away. And then anything that's not in the LOI, they have an easier time jamming down your throat in definitive documents later, right? During the LOI, you've got typically one attorney, one accountant that's advising you. They've got somebody, probably internal counsel, maybe one person from outside counsel advising them on the LOI. Once the LOI is done and you're in definitive documents, you know, both have big legal teams, big accounting teams, boards are involved. Getting anything changed is harder and more expensive later, right? So get as much of your negotiating done early as you can, as much as you might want to get that LOI signed quickly and get a deal locked up and know that you're going down the path to definitive documents. This is the one time that you have to really make sure that you've squeezed everything you can out. Because like Paul said, it's very difficult for you as a seller or them as a buyer to come back and say, I know I told you that I was going to give you this, but really I'm not going to give you that. That's an act of bad faith that makes every negotiation hard. I have not seen that kind of bad faith in all the transactions that I've done. Usually when deals terms change, it's because, hey, we found this in due diligence and therefore this, or business terms change and therefore that you didn't sell as much as you said, so the price is going to change. But all the fundamentals have to be in the LOI. It's the easiest to walk away from, and it's the only time that you have the one thing more powerful than your ability to walk away. You have other buyers at the table until you sign that LOI, and that's going to help you get what you need.
Yeah, just
My ears, Al. Glad to hear. Ben, go ahead.
Yeah, just real quick on that, just another point is that it's super important to bring in guys like Paul and Jeff early in the process, like way before the LOI, because the LOI is the terms. And, you know, a guy like Jeff can save you an amazing amount of tax money and just have the right structure for both sides in the LOI. But you need to consult an expert like Jeff to get the right structure. And then Paul is going to have excellent ideas on structure as well. And, you know, sometimes the LOI have things like indemnification pools and how large those are. And you know what? You need to have Paul there because Paul's going to tell you what's market. And that changes every day.
And Paul and Jeff won't tell you this, but that doesn't mean call them when you have an LOI in hand and say, read this and tell me if it's okay to sign.
Exactly. Thank you.
Okay. It's too late.
How's this?
Right?
Although
Yeah.
that's for sure better than sending it to me with a signature on it,
Right.
which has certainly happened. It's certainly happened. All right, let's move on. M&A process. Okay, diligence. Excuse me. This is the point where the buyer is going to want to learn everything about the company. It can be a lengthy process. It's a difficult process. It is invasive, but it is important. And you got to take it seriously, especially as the seller. It covers business, financial, legal. It can be staged if appropriate. I will sometimes recommend to my clients that if there are certain certain things about the company that are really super important and super confidential, you not turn those over early in the process. You let the process advance before you make certain information available. I mean, that's, there's more to talk about that, but something to think about. Remember that full disclosure helps you as the seller. It's really important that if the buyer asks a question, like, I want to see all of these documents, or tell me any litigation that you have going, or whatever it is, if you answer that, if your lawyers advise you to answer that question, when you answer it truthfully and fully. Do not hold anything back, because if they asked you a question and you were not forthcoming, that can come back. So, for example, they said, please, tell us any litigation that you have outstanding, and you fail to tell them about one case. If that case later proves to be a loss to the buyer, they will very likely, under the terms of the agreement, have the ability to come back at you and to dock the purchase price, because there will be a holdback from the purchase price, and they will deduct from the purchase price what they lost because you did not disclose fully. So disclosure is your friend. And I say that because there is a tendency to, you don't, like, you're holding back the bad news. You don't want to give them the bad news. Before the deal is signed, you need to make sure that the bad news is out there, because it'll help you at the end of the day. How it gets out there is super important. Don't let the buyer find it by chance. If there is bad news out there, you and your attorneys, accountants, your team need to know about that and position it properly. And look, every deal, there's always something that comes up. There's some problem. Even in the best of deals, there are issues. You as a seller should know what those issues are, and you should know how and when to get that news out there. Because when the buyer, if you disclose it, the buyer, that's a sign of good faith. The buyer will appreciate that. If the buyer finds it, then they'll get nervous. Well, what else is the seller hiding from me? What are they trying, to conceal? So you want to establish a feeling of good faith and openness. Prepare for diligence in advance. The cleaner your records are up front, the easier the process. Do not begin to assemble your data room, when you get the LOI. I cannot tell you how many times I've seen that happen. This goes back to what I was saying before, the other event on long-term planning for an acquisition. If you know that you're going to be in a sales process to sell your company several months down the line, you should be talking to your internal team, to your lawyer, accountant, banker beforehand to make sure that you are ready to go. And that, when the LOI comes, boom, 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 you can roll out your data room, get it going. Don't neglect buy-side diligence, especially if part of the purchase price is going to be stock, or if there is going to be an earnout, or even just if you as a principal are going to be staying with the seller, staying with the buyer for some period of time after the sale, you want to know a little bit, at least a little bit about the buyer, and feel comfortable what their track record is. They're financially sound. They will be a good solution for your company. Guys?
Yeah, what I've seen, one of the things is clients came to me, or prospects, came to me, and they were a pretty small company a few years ago, and now they're getting much bigger and they have the same advisors in place. And, the first thing I say to them is, what states did you file in? Specifically, I don't know, I live in New York, everything's in New York. Well, where are your clients? What do you do? Where's your server? And you start asking a bunch of different questions, and then they have an employee in California and she works out of her house. And you get to it and you say, well, wait a minute, you have income tax filing obligations in numerous states. Maybe you should have had payroll taxes in those states. Maybe you should have had sales tax in those states. Oh, in these certain states here, maybe you should have had personal property taxes. Now, what happens is, if you get these questions because the buyer has a checklist and they ask you these questions and you say, how do I answer? You're going to have a big problem. Now, if you can quantify all these things before, and all the schedules, and see what you want to do, because you have to make a decision, do you want to fix the things or not? Sometimes it's practical just not to fix the things. but you have to know how that's going to affect the deal, how much money, what you're going to have to put in escrow, what the terms, what you want to do, what are you prepared to do? Don't listen to them for them to tell you just file all these returns and go back, the last 10 years. Maybe that's not the right practical decision. So figure out what you did wrong first and figure out the most practical way to fix it, and then how to tell the buyer.
Ben, Al?
Yeah, so Jeff's absolutely right there. Do your own diligence as a buyer in advance. Figure out where the things are that could go wrong, figure out how to sell against them. If you wait until you get the question, and then you've got to come up with how do I phrase this in a way that's going to have the least risk, way harder to keep a deal on track than it is to know from the beginning before you start, these are the things I have to sell around, these are the things I have to work around. If I disclose them early in the process, they're not likely to affect deal value later, right? So as hard as this is, do it. The other piece of advice I'll give you, because half of the deals that I've done, almost half, have been buy-side deals, is that that perfect data room that you're planning on giving us with all the financials perfectly in order and no contracts that don't have the right stuff and everything, we don't buy it. Like, we, as buyers, if we've done enough deals, we know there is no such thing as a deal without hair on it. So you trying to present a deal that doesn't have hair on it just tells us that we have to look harder for the hair and makes you less credible. So coming out with, hey, by the way, here's the thing that's going to be the hard thing for you to get around early in the process actually really helps you. Ben and I did this on the last deal, like in the first conversation when corporate development got serious after the business buyers wanted to do it. We said, hey, Joachim, here are the 3 things that are going to be hard for you to swallow. Why don't we focus on those first and get through them? And boy, that made the deal go so much faster. Ben, what was it? It was like a 6-week close or 8-week close, I think.
Yeah, exactly. Yeah. It gives you a lot of credibility too, Al, because you're revealing your dirty laundry up front. Gives you a huge amount of credibility. You tackle the issues and you're good to go. I had a deal recently where it was actually post LOI. During the process, client called up and go, I just lost my 3rd largest customer and they represent 20% of my revenue. So how do you want to handle that? I go, well, what good things happened to you lately? He goes, well, a lot of good things, a lot of new contracts, expanding this territory. Great. Give me a PowerPoint with 2/3 the good things and 1/3 you lost your 3rd biggest customer. So he did that. And I said, you're going to present that now to the CEO on the other side, not the private equity guy, the CEO. Presented it. CEO was very impressed. No price cut. So you got to sandwich the good with the bad.
That's been very good advice. We had one question about what are the typical crown jewels in a transaction. This is the thing that really gives your company the most value. Now, it's not always the case. I mean, for a financial buyer, they're looking for your revenue stream. But in certain deals, especially strategic deals, there may be something that is of particular value to the buyer. It might be your IP. It might be your team. It might be your customer list. I did a deal for a money transmitter deal years ago, and the company had 20,000 locations across the US. That was really what was of most value to the buyer. And so that list of the locations was kept under wraps until very close to the end of the process. So every deal is different, but the point is, know what it is that's important and make sure you're really protecting that, because if if the deal goes south, that's more likely your company will be damaged if that sort of information gets out there. All right, let's move on. We got to move a little faster. This is all good stuff. We're going to go over this next slide pretty quickly. Then once the LOI is signed, the lawyers get to drafting and negotiation of definitive documents. We talked a bit about this a little bit before. This is really inside baseball for the lawyers. Super important. And you as the principal need to focus on this. You can't leave this completely to the lawyers. You need to know, especially if things are getting stuck on certain points, know what those points are and make sure they're being properly negotiated. And the things that you care about are being focused on. Disclosure schedules. We talked about diligence. This is sort of the companion to diligence. These are the lists that you provide that sync up with the purchase agreement that list a great deal of information about the company, all of your material agreements, your most important customers, your employees, your litigation that you have, any problems that you have with ownership of your IP. The list goes on and on. This is where you are going to own up to and commit to the condition of your company. Like diligence, get it right. You don't want to leave stuff off of those disclosure schedules. It should be included, because if the buyer suffers a loss because of something you did not include on a disclosure schedule, you will likely be held accountable for it financially after the fact. Then comes signing. Sometimes
Can I interrupt you, Paul? Because there's a
Yeah,
step
please.
before signing that's not on here. And
Please.
Ben laughed at me when I brought this up to the buyer on this one, but there's one more stage that I call the one thing. In 38 deals that I've done and 6 deals that have not been completed that I tried to do, there's 100% of the time been one thing within a couple weeks of signing that goes sideways that puts the deal in jeopardy. Ben's example of lost the third biggest client. I have one deal that didn't close, was a medical treatment business that the state of California decided they were no longer going to fund that kind of work that was going on, and that killed a deal. On one of the deals I had, it was employees, former employees who hadn't signed away their IP rights and actually assigned the IP rights, and we couldn't get the employees to actually sign to do the assignment, and that slowed down and put a deal in jeopardy. 100% of the time, there's going to be a point where you go home with a knot in your chest and you tell your boyfriend, girlfriend, husband, wife, kids, best friend, whatever, I think this thing's going in the toilet. I don't know if it's going to close. It will happen 100% of the time. I address it at the beginning of the process by making a deal with my buyer or my seller. Hey, we all know this is one thing is going to happen. Let's make a plan for, we're going to get on the phone and we're going to work through it without all the lawyers and accountants until we figure out how to get through it, right? And that's what happened on this last deal that Ben and I were with. And we used to joke every time we get on the phone, we can't be ready to close yet. The one thing hasn't happened. And when the buyer found one thing, he called me and he said, Al, found the one thing, right?
Yeah.
But emotionally, and Paul talked about the emotional toll on this earlier, you have to be ready. You have to know that if I've never done a deal without the one thing, Ben has never done a deal without the one thing. Paul, have you ever done a deal that didn't have the one
There's
thing?
always one thing. Yeah.
There's always the one thing. So if you know that going in, you know that as you get close to the end and you start counting the money, that you realize it's all going to feel like it's being taken away, that you can work through it, and that I've closed 38 successfully, even with the one thing happening on all of them. Be prepared, because it is going to happen. It's an important step, even though it's not part of anybody's project plan. Sorry for interrupting, Paul, but I feel like
thanks, Al. No, a good point. I'm just going to keep moving. We're going to have to move a little faster here. Okay, signing and closing. Sometimes it's simultaneous. I'm sorry, if we can go back. We're not ready for the next slide. Sometimes it's simultaneous. Sometimes there'll be a period of time between signing and closing for various reasons, including third-party consents. A party that has a contract with the seller may have a right to consent if that contract is going to go along with the deal. There may be regulatory issues. Closing, simply the consummation of the transaction, money change hands, title to the company or the assets changes hands. Post-closing, so there's usually some post-closing activity. If there was a working capital that you agreed there would be $1 million of working capital that goes along with the company. If that number wasn't quite right, there'll be a price adjustment. I mentioned about escrow claims. There will often be a holdback from the purchase price to fund anything that goes wrong after the closing. So after the closing, if there are claims against the escrow, against the holdback, those will be made. Money will be released either to the buyer or seller, depending. And then if there are earnouts in the deal, meaning that the part of the purchase price is conditioned on achieving certain milestones, there'll be a period when those earnout milestones are, as the seller, the team is working towards those milestones to get their payout. Guys, can I move on? Next slide. All right. Okay, negotiating the LOI. We've talked about, we've gone over some of this already. Negotiating dynamic. As Al noted, this is the point of maximum seller leverage. Take advantage of it. Because after the LOI is signed, as Al notes, deal terms often erode for the seller. As Al said, the purchase price, I won't say 100% of the time, but generally speaking, it only goes one way, which is south. It goes, the seller loses money. That's not 100% of the case. I mean, if the purchase price is based upon metrics that improve, okay, that may be something different. But often what happens is that bad news comes up during the course of the diligence that gives the buyer, ammunition to go and try to knock the price down. In addition, as we noted, that as time goes on, the seller tends to get more locked into the deal, and it becomes more difficult for the seller to get out of the deal. And so that also has a way of eroding the seller's leverage and increasing the buyer's leverage. So that can also come up, news of the transaction being leaked. So what does that mean in terms of interests? As Al noted, what does the buyer want? Well, the buyer wants a long exclusivity period. They want to have a good long time to get the deal done. They want to get all the information up front in the beginning. Remember those crown jewels? They want them day one. And they want maximum flexibility as to deal terms. As Al noted, they want to be as tied down as little as possible, because they want to be able to use that. I hate to attribute bad motives to all buyers, but as Al noted, this is to some extent the nature of the game. They want to be able to take advantage of bad news as it comes up, gaining negotiating power, and potentially use it against you as a seller. The seller, on the other hand, wants no exclusivity period or limit it, and they want to lock in everything at the top. They want to get the price locked in. They want all the big deal terms locked in, because, again, going back to what Al said earlier, they don't want to be negotiating these important terms late in the process when they've got limited bargaining power. Guys, what do you have to add to this, if anything?
You're spot on there.
Good, right on.
All right, we will move on. What are the key terms? We've talked already a little bit about transaction structure. Jeff, you can go into this again, but we got about 10 minutes left and about 3 or 4 slides. So
See if I could do this in like 4 minutes or something like that. It could be like a 3-hour conversation, but here at the end of the day, you want to know your tax costs. Your tax costs are key, specifically. And it could be a tremendous difference, like I said before, what you're selling. If you're selling your stock, if you're selling your entity, or you're selling the assets. Now, the buyer generally wants to buy assets. The reason the buyer wants to buy assets is because he gets what you call a step up in basis in the assets. So it's the full fair market value, what he paid for it. Whereas if you bought General Motors, their plant doesn't increase in value, specifically, it stays the same. So if the buyer gets an increase in basis and assets, he can get an immediate write-off in a lot of cases for that, turns into cash in his pocket. He could amortize goodwill over 15 years, put cash in his pocket over 15 years. There's numerous reasons why the buyer wants to buy assets, specifically. And here, if it wasn't in the LOI specifically, what kind of deal it was, the buyer might pay you extra. We said before, the buyer's never going to pay you extra. I could tell you here, if the buyer wants assets specifically, the buyer a lot of times says, I will pay you extra. What's it going to cost you? Now, a seller, the general rule is a seller wants to sell the entity. That was generally the rule, okay, until something happened this year. So the seller usually wants to sell the business, get out of the business, that's it, pay capital gains, the lowest rate possible, and selling his corporate stock and be done with it if possible. Whereas if the seller were to have a flow-through entity like a partnership or a S corporation, what happens is the seller could be in Florida and you pay no state and local income taxes in Florida. Whereas if he has a flow-through entity and he sells the assets, he could end up finding out he has taxes in all of these jurisdictions that charge you a lot of money tax, New York, California, and so on, and then you get no credit because you live in California. So entity level taxes could be a disaster for the seller if you don't do things right. Then besides the actual taxes to other states, you could be a corporation and then you could pay a double level of tax. You pay tax once when you sell the assets, then you take the cash out to yourself, you pay a double level of tax. If you're not aware of that, when you find out your after-tax cost, you're going to be pretty surprised. Then what happens is, we said there's different rates when you sell. You could have capital gains, which are generally 20%, and ordinary income, which is generally double that, specifically. If you end up selling assets, you could have double the tax rate on a lot of assets than you would if you just sold the entity. So you have to be aware of that. Something new came in to change that a couple of years ago. Generally, they changed, you couldn't deduct state and local taxes anymore. Trump put that in, said, you can't deduct for the most part other than $10,000 state and local taxes. The states put something in that the IRS blessed at this point. It's called a pass-through entity tax, where the entity could pay your taxes. So you get a full deduction for the taxes at the federal level. If you're getting a full deduction, you're saving a lot of money. So you have to weigh both of these and make sure you have all the elections in place. And a lot of people miss that because they've been doing deals for a lot of years. They don't take that into account. But that could be a tremendous savings, for you. And then, what happens a lot of times, I said, you could end up getting stock, specifically. If, you're going to end up getting stock, you have to look at different type of things. Maybe it could be tax-free. I'll go through it after if we have time. If sometimes your attorney says, look, you have to sell the entity. We can't retitle all of these assets. Well, there's different ways with mergers and conversions and different elections to treat an entity sale like an asset sale. There's all different ways we could do that. If it's in corporate form, I put down a couple of elections. If it's in some other type of form, there's all different ways with mergers and reorganizations. We could put everything together. And just the final thing that I just want to put real quick, you shouldn't forget this. I'll just tell you this in 2 seconds, and then I'll stop with this slide because I probably went on more than Paul wanted me to. But if you sell corporate stock, certain corporate stock, you could sell it totally tax-free. Okay, if you make certain characteristics, it's called 1202 small business stock, totally tax-free. If you meet this, and you could structure into this if you have time. If you can't meet this specific criteria to sell it tax-free, you may be able to sell it tax-deferred. You can get another entity, take all your cash, invest it into another small entity. If you invest it in that small entity, you may be able to defer all the tax. So really important, and I think you should know this beforehand before you sign the LOI or move too close to any part of the deal. So that's where I am.
Jeff,
I'm just going to add to what Jeff is saying, is that as entrepreneurs, we don't have to know any of this. This is why we have Jeff, right? Is when we get to this level of complexity, these things change every day, right? Literally every month, there are new guidance, new options that come. And so every deal, you're going to be surprised. Your tax advisors can come back and say, hey, there's money here you didn't know about, or there's risk here you didn't know about, right? So it's not just help me account for the money and pay as little taxes. This is complicated stuff, and you need a good tax advisor.
Absolutely. Totally agree, Al. It's really key role. And then again, the whole private wealth management as well, and saving taxes by, doing it really early in terms of forming trusts and certain valuation. Jeff, I'm sure you go another hour on that one, but
Yeah, easy. Yeah.
It's very important to consult with a guy like Jeff, no question.
all right, let's go on to the next slide, which we will do quickly. Continuing through non-binding terms, I'll just mention, we talked about transaction structure. Jeff mentioned the tax aspects of it. There are legal considerations as well. How liabilities are apportioned. In an entity sale, the assets and liabilities all go along with the sale. In an asset sale, Maybe only some of the assets go with the sale and some are left behind with the seller. Maybe liabilities are left behind with the seller. So there are a number of considerations involved in that decision between an asset deal and an equity deal that need to be taken account of. Listing the assets, consents we talked about before. Another key term, obviously, in the LOI is the price. Not only the aggregate amount, but how is it going to be paid? What portion of it will be in cash? Will any of it be in stock? Maybe there will be a note. That is to say, there'll be payment over time. Then you need to think about what are the terms of that note? What happens if the note isn't paid? Earnout, we talked about before. Is there going to be earnout? Everyone kind of likes the idea of earnouts in concept, but when you start negotiating them, oh my God. Al is shaking his head. I know Ben feels the same way. I mean, I have just spent, as a lawyer, negotiating an earnout. It can be a really painful process. It's, again, great in concept, challenging in execution.
I've done 3 earnout deals. All of them had the same result. After the acquisition completed, the buyer's hands were tied on how they wanted to run their business because they had to operate a separate P&L of the business being purchased in order to be able to achieve an earnout. One of them actually maintained it the entire time to their demise. It was not the smart decision. And the other 2 tore down the earnouts within 6 months of closing the transaction because they wanted to repackage a product or restructure an organization. And a 3-year earnout was too long and prevented them from doing it. So stay away from them. Buyers, stop asking for them. They're not good ideas.
Absolutely agreed. And then escrow we've talked about before. That's the amount that may get held. That's probably going to be held back to fund any liabilities that come up post-closing. Jeff, we've already talked a good bit about tax implications. I think maybe we move on. That there are. Speak to Jeff about the tax implications of the payment.
Can I just ask you something just over here? We have a breakout room after, right? So if somebody has a question, on the tax implications of a note or an earnout or anything like that, and they want to talk for a few minutes, I'll be on there after, specifically, because there's a lot, here. I was going to take, a few minutes on that, but, here we're running a little bit behind, so they could jump on it after.
All right. Very good. Thanks for that, Jeff. Okay, then we go on more of the non-binding terms. If we could have the next slide, please. So in an asset deal, there's going to be a description of the assets and liabilities. We talked about that a little bit. Working capital assumptions and related purchase price adjustments. Again, we spoke about that. Maybe there's a certain amount that needs to go along with the business. And if you don't get that, there'll be an adjustment after the fact. Employment terms. This is important. And it is correct. I think maybe it was Al who noted that there's a way that this doesn't always get focused on sufficiently early on in the process, and that can be a mistake. And I've gotten term sheets, I've gotten LOIs for my clients, and there's just some bare reference to employment, but none of the terms. I'll say to my client, like, you want to know now, at least high level, what the terms of your employment are, and we'll go back and demand that gets included. Non-competition.
You should have an ask on this, right? So don't just wait for them to give you an LOI and say, I don't want to be tied up for 3 years. During the early stages when you're negotiating is when you want to be able to say, hey, you know what? I would love to join your company for a couple of years, and then I want to be free to pursue the next business that I want to do. So I'm looking for a 2-year employment agreement. Or, I've taken this thing as far as I can. I want to make sure you get the most out of it. I want as short of an employment agreement as I can. And then I want to turn it over into your hands. Know that stuff up front, right?
Just one other thing with that, when you talk about the terms, I've went through this a lot of times where somebody had a large employment agreement, and the employment agreement is going to be taxed at the worst rate, the highest rate specifically. So what I try to do a lot of times is somebody's going to get a few $1 million a year. I say, well, maybe we can cut that down substantially, get some more money in the sale of the business, and then you cut the taxes in half. So just something to think about.
Non-competition provisions. There will be non-competition provisions in the agreement, and understand that in the situation of the sale of a company, they are generally more enforceable and for longer periods of time than in the employment context. So do think about them, understand how they will impact you, because if you're facing a non-competition of a few years, that can have a meaningful impact on you. It is significant. Pay attention to it.
And just to go back, just one more thing, I just want to mention, non-compete, just again with a tax issue. Sometimes you get paid for the non-compete. A lot of times you put a dollar amount in the non-compete. If you're going to put a dollar amount in the non-compete, specifically what it's going to cost, that's going to be taxed again at the highest rate, specifically. So it's good to put a dollar amount in specific. I like to see a dollar amount, but don't go too high. Keep it lower.
Absolutely right. And then non-key employees. As a seller, you're probably going to want to know what's happening with the employees other than the founders and the key employees. How are they going to be treated? What are their employment terms? Employees are rarely unimportant in a transaction. It's often they are the most important thing, but they will not be unimportant. So think about those, the provisions with respect to employees early on. Purchase price allocation. Jeff, can you give us 10 seconds on that?
Yeah, the purchase price allocation is pretty important because certain assets you're going to have, do not qualify for an installment sale. I said you want to pay it over time. So if you value certain assets high, you might have to pay tax immediately on that. And then also certain assets, if they're not good assets and there's more ordinary income, you could pay a lot more. So you could end up putting the purchase price to the assets that benefit you, which might not even make a difference to the other side. And sometimes they do, but you could work it out with them.
Yeah, this is a negotiated provision in terms of how the purchase price is allocated across assets, which affects their tax treatment. Indemnification, we talked about escrow. If under what terms can the buyer come back and say to the seller, you did not disclose the full condition of the company, or you did not give me full information, or things did not turn out as you obligated they would. And the buyer will be able to come back to the sellers, and that escrow we talked about, that money they held back from the purchase price, there will be a claim against that escrow, and money that you want to be going into your pocket will end up going to the buyer in indemnification for losses that they suffered. Again, that's why diligence is important. That's why disclosure is important. Founder liability does come up in deals sometimes, maybe sometimes around certain terms like intellectual property or other key terms where there will be liability not just of the company, but actually of the founders individually. That's something that you as a founders are for sure not going to want, are going to fight against, as will your lawyer. Sometimes you will be successful, sometimes you will not be successful. Al, do you want to say anything about that?
I love that this is part of the LOI conversation that we're having, because it's something that's really often overlooked on buyers to put clauses in the LOI about founder liability. And it's something that always shows up in definitive documents later. And then you've got a founder that's got to make a hard decision, right? And if they're going to take it, then they've got to be able to negotiate with the other stakeholders, other investors. Hey, I'm taking on a disproportionate risk. I should be taking on a disproportionate amount of the proceeds to compensate. It's a very complicated thing to get around. And usually it has to do with IP, right? Because if you're a small company and you're being bought by a big company, the likelihood of you as a small company getting sued for IP infringement is relatively small. You don't have deep pockets. But as soon as that entity gets bought by IBM, Cisco, BMC, name your big technology company, now they have big pockets and they become a target, and they're going to want to protect themselves. And so they're going to want to say, hey, if we gave you $100 million for this company and 80 million of it went to the founders and the IP wasn't locked up, we want to not just be able to come after the escrow, we want to be able to come back to the founders for a portion of that, and that's disproportionate. So you got to figure this out in the LOI, and you've got to make risk-adjusted price adjustments.
Yeah, sometimes I'll recommend my clients negate that in the LOI. I mean, again, this is why you want specificity in the LOI, especially as a seller. Let's go on to the next slide. Last slide. no, I'm sorry, this is the last slide. Okay, the reps and warranties, this is simply where you are, as a seller, committing to the condition of the company. Again, there is no litigation. Here are all of our material agreements. Whatever. Again, get it right. Make sure that those reps and warranties are correct. And if you do have a litigation, make sure it's disclosed. But the point for the LOI is you want the key reps and warranties set forth here, because if there are any unusual, it'll often be articulated as customary reps and warranties. The buyer may want to slip in other reps and warranties along the way. If you have customary reps and warranties, or better yet, if you list the reps and warranties in the LOI, that forecloses, especially in the latter case where you've listed them, the buyer trying to slip any in later and you getting into an argument over, well, what's customary? So any terms critical to the parties that are not customary. Okay, again, same issue. The LOI is 7-10 pages long, 5 to 10 pages long. The definitive documents are like 50, 70, whatever pages long. There's a lot of detail contained in the definitive documents. The LOI is the point for any terms that fall out of the ordinary, especially as the buyer, frankly. This is where the buyer wants to get in the terms that they don't want to have to argue about later. But if on the seller side, if there are things that you care about that are not customary, for goodness sakes, get them into the LOI, because you don't want to be trying to get them into the deal later. And the proposed closing date will also appear in the LOI. The binding terms, the ones that can be enforced against you if the deal doesn't close, are limited but important. The lockup period, if the seller goes and sells the company to another party before the lockup period closes, they are in breach, and they could be held liable for the breakup fee that the buyer will come after them for. That's the fee if the seller does not go ahead with the deal. Confidentiality, confidentiality survives the LOI. So if the deal doesn't close, it survives the deal goes south, the confidentiality provisions are binding and continue, and they are important to you, whether they're contained in the LOI or in a separate NDA. But as a seller, those terms are very important. Any covenant regarding the conduct of the business after signing the LOI, those can be binding terms as well. Pay attention to them, because that gives the buyer some say in how you run your company if you agree to it. So you have to be very careful about agreeing to provisions like that. Allocation of cost doesn't come up that often, but sometimes buyers will pick up a portion of fees of a seller. It doesn't happen that often, but that would be a binding term. And the termination date, the date by which, if the deal is not closed, the LOI is no longer the non-binding. The LOI goes away except for the binding terms. Closing words on these points, guys?
Yeah, I got 2 comments. One is that the larger deals, I was on a buy side for 330 million. We actually we were asked by the seller to send in our purchase agreement, right? Our standard purchase agreement for this deal, modified for this deal, so they could review purchase agreements from all the potential acquirers, which was interesting. So as post LOI, they said, here, send in your PA. So that was interesting. The other aspect is, it's always helpful, and I do this for all my clients at the very beginning of the process, is, what are the goals of the founders, right? Do they want to stay on board with the buyer potentially of larger company? Do they want to go and start a competing business? Do they want to go do another startup that's not competing? There's a lot of wrinkles there. Do they want to go play golf for the rest of their life, which is not likely? But it really does affect the LOI in terms of the employment agreements, non-compete, and a lot of other areas.
Ben, thank you for that. All right, 30 seconds to wrap up. Jeff, why don't we start with you? any closing thoughts?
Yeah, take this slow, be careful, because if there's a mistake, it's very hard to fix a mistake and it's very costly. And I hear that almost daily. I wish I would have known that, specifically. So take your time. You're not in a rush. Get the right advisors in place and you'll be fine.
Ben?
Yeah, I think the team is the most important component. Back to what Al was saying earlier, field your best team and make sure that you trust your team, and so you can focus on the business.
Al, last word?
I think we all agree that the team matters. This is going to be most likely the biggest transaction you've ever done and will ever do in your life. Don't be cheap about your team. Don't shortcut the time. Tell your family that you'll see them when it's over. Tell your coworkers they need to cover for you. You're all in on this. Do it right and surround yourself with winners who've done it before, so you don't get walked over by guys like me.
All right, with that, thank you all. I'm sorry we went over a little bit, but so much good information. Ben, Al, Jeff, really appreciate your insights. Most of us will be staying for networking after. You can meet us in the breakout rooms for any questions we didn't get to answer. And do go to the YouTube channel of Tech Alliance, the resources page of my firm website for some of the other programs we've given on these and other issues. Thanks again. Doug, we'll turn it back to you.
Hey guys, fantastic presentation and conversation. Thanks so much for being with us today. And thanks to everyone who joined in. Hopefully this was helpful to you and you'll get the best deal possible for yourself.